Affidavit of ability to pay court costs. Petitioner Charity Colleen Krause submits the following as evidence that she did and does in fact have capacity to successfully fulfill terms of repayment on any loan agreement that was or is legally engaged by making relevant deadlines concerning reporting and deposit, as well as providing work products that are valued in manners for which Krause should be highly compensated with financial remuneration with which to invest as she sees fit. Krause has contended and continues to contend officially since May 11, 2017, that her identification documents and other personal and tangible property had been stolen and used in commission of crimes while she was reissued forged and fraudulent documents. Krause diligently and consistently reported to numerous local, municipal, state, federal, corporate, banking and financial services, and international agencies her efforts to track these stolen documents and the crimes that were connected to them, as well as seek reissue of official legal identification documents that were not themselves complicit with any illegal activities. Krause officially began reporting in March of 2016 her understanding of the fraud scheme to which she had been subjected while in Chicago, Illinois. Krause sought assistance beginning in early November of 2016 with follow-up upon being forced to flee to Houston, Texas on November 1st, 2016. These efforts are recounted in numerous reports and legal filings, including the one referenced to this filing with the Supreme Court of Texas. To date, Krause has tracked how her allegedly official identity documents have been involved with securities fraud, which goes back to the issuance of her first driver's license from the Commonwealth of Virginia in May of 1993. Krause additionally was obligated to, quote, debt service, end quote, terms that were unconstitutional and in violation of standard contract law prior to her 18th birthday, in the form of federal education, quote, loans, end quote, that were actually capital outlays in connection with later Treasury issues via terms explicated in the 1993 Omnibus Reconciliation Act. Had the terms of the contract in which Krause had been engaged as a minor below the age of consent not been intentionally misrepresented, Krause would have been able to make informed decisions about whether or not to accept the original terms of the, quote, loan, end quote, or seek financing elsewhere. Krause, however, was deceptively engaged in, quote, debt service, end quote, performance terms while still a minor that have attempted to mischaracterize her work products, personal, private, tangible, and intangible property, or other aspects of her identity in order to cover up for crimes committed by others, including crimes Krause herself has tracked and reported to numerous agencies. As such, Krause submits this affidavit as proof that Charity Colleen Krause, with Social Security number, in lieu of any derivative use of her identity by others, with whom she has never consented to engage in a contractual relationship for derivative use, does in fact have the means by which to pay for all of her court costs, legal and filing fees, as well as a means by which to support herself independently of public assistance and in compliance with the law. Others who have defrauded the requisite agencies or that refuse to assist Krause with recovering her identity, which includes appropriate prior disclosure by others of the true intentions of their efforts to engage Krause in any contracts, as well as compensation accorded to others instead of Krause, bear the burden of proof in regards to subsequent classification of, quote, risk, end quote, or, quote, liability, end quote, that were misassigned to Krause, her work products, or any accounts that make use of Krause's identity information via INRI International Profit Association. This was signed at 12:46 p.m. Central Standard Time on August 6, 2019. There is a fourth page of this four-page document titled Addendum. Krause contends that there are many available examples of the referenced proof described herein. However, in an effort to prevent any potential conflict of interest, and in an effort to prevent for the potential of any acts of fraud in connection with appropriate ascribement of account activity, Krause agrees to present as evidence the herein referenced proof after a formal evidentiary procedure has been officially secured and matters of jurisdiction have been resolved. Kraus requests the court exercise its discernment concerning matters of concurrent jurisdiction in consideration of the herein referenced, and either grant a hearing within 20 days to resolve this matter under the jurisdiction of the Supreme Court of Texas, or officially release this and other connected matters from their jurisdiction so they can be reassigned to the appropriate courts for immediate consideration.